The broadcast is now starting. All attendees are in listen-only mode.
Good morning and welcome to this webinar on an introduction to anti-dumping. My name is Jody Roussel, spokesperson for the Alliance for Affordable Solar Energy, or AFASE. AFASE is an alliance of over 80 companies active in solar that believe free trade and open markets are key to a competitive European solar industry. These firms have joined AFASE to build a voice for the European industry to speak out against the negative impacts of market protectionism. As a service to industry, AFASE will be hosting a series of webinars to educate solar industry companies on the recently launched anti-dumping complaint. This complaint could result in significant cost increases for industry, and we aim to inform you how to engage the European Commission investigation process and how to protect your right to a voice in the upcoming 15-month investigation. To begin our webinar for today, please let me introduce Ms. Paulette van der Schoren, partner with the law firm Mayer Brown in Brussels. Ms. van der Schoren brings over 30 years' experience in both anti-dumping and other trade dispute resolution. Ms. van der Schoren, welcome and thank you for joining us today.
Thank you, Ms. Roussel. Ladies and gentlemen, welcome to this webinar. This is Paulette van der Schoren speaking. And before we dive into the substance of our subject, I would like to mention that if you have any questions at any time during this presentation, you are welcome to type your questions into the chat box, and we will try to respond to as many questions as we can at the end of this presentation. During today's presentation, we will touch upon 5 issues, and the first is the conditions to impose anti-dumping duties. The second, who complains and what are the products concerned. The third is the schedule of the investigation. The fourth, the decision-making process towards a decision in the investigation. And the fourth, and but not the least, the role of the solar market players in this investigation. Let me now turn to the first subject, and these are the conditions to impose anti-dumping measures. 4 conditions are set forth in the anti-dumping regulation, and they must all simultaneously be met before the EU can impose anti-dumping measures. First and foremost, the products targeted, in this case solar products, must have been sold to the EU at dumping prices. Secondly, the union industry producing the products concerned, again, in this case the solar products, is suffering material injury or threat of injury. But on top of that, the injury concerned must be caused by the dumping prices. And then the fourth condition, which is a very important one, especially for the downstream industry and the suppliers of solar products manufacturers, is no anti-dumping measures can be imposed unless they are in the union interest. Now, what is dumping? Oftentimes, it is thought that dumping is selling at a loss. That is not exactly correct. The actual definition in the EU's anti-dumping regulations is that dumping exists when the sales price for export to the EU 27 member states are below either the home market prices, in our anti-dumping jargon, normal value or NV, or below the cost of production plus profit. This is then referred to as constructed normal value, or CNV. Now, these home market prices and the cost of production are in principle established in China. The difficulty here when China is concerned is that the EU still does not consider China as a market economy country, and therefore considers that with some exceptions, home market prices, cost of production in China cannot be taken into account, but instead must be based on the home market prices or the cost of production in an analog country. And that's exactly what is in the anti-dumping complaint here, where we understand that the complainants have proposed the US as analog country. I said that China is a non-market economy country, and that with some exception the home market prices cannot be taken into account. There are, however, possibilities for some Chinese companies to prove to the Commission that they operate as if they were in a market economy. If that is the case, if they met these tests, and these tests are very difficult to meet, then their own home market prices and cost of production in China will be taken into account. Simplistically, what does this mean? If you have a normal value of 100, if you have an export price of 80, the normal value exceeds the export price, and therefore theoretically there is dumping. Now, what we call the dumping margin is then the difference between this 100 and this 80, that is the 20. That is for a simplistic explanation of how dumping is determined. How does the EU proceed to determine whether there is injury or threat of injury? Well, when it determines whether there is dumping or not, the Commission looks at a shorter period, which is still normally a one-year period, the 12 months immediately preceding the initiation of the case. But when it comes to the determination of injury or threat of injury, the Commission looks at a wider time period in order to determine what is the trend over this time period. In this case, most likely it will take into account 2009, 2010, 2011, and into 2012, probably until the end of June 2012. And it will look at the volume and the value of imports of Chinese solar products into the EU. Threat of injury basically means that injury as such does not exist during this period, but that the trend is such that it can be forecasted to occur imminently and foreseeably. So therefore, threat of injury that is clearly foreseeable and imminent can also lead to the imposition of anti-dumping measures, even if there's no injury as such. For the assessment of injury and threat of injury, the EU will proceed first to look at the volume of imports of Chinese solar products in terms of the absolute amount to determine whether or not there's an increase of imports. But it will secondly also look at the volume of imports relative to consumption. In other words, have Chinese solar products increased market share or not? It will then also look at the prices for Chinese versus EU solar products. And it will try to compare like with like. It will try to determine a Chinese product and take a similar EU product. Are the prices for the Chinese product below the prices for the EU product? Alternatively, and in combination, it will also look at what is the price trend for Chinese products. Have prices decreased constantly or by surges? And if that is the case, what is the impact on the prices of EU solar products? Have the prices for EU solar products been depressed or not? And then it will look at the impact of the dumped imports on the EU manufacturers. Now, what it looks at is 15 economic factors, amongst which the most important ones are sales, profit, production, capacity utilization, market share, but also items like investment, employment, cash flow, return on investment. Now this may lead to a determination that there is injury to the EU solar manufacturers during this period. But that in itself doesn't mean that it is sufficient to impose anti-dumping measures. The EU will still need to look at establishing a causal link between the imports of Chinese solar products and the injury found to exist. And that causal link, unfortunately, often is based on the coincidence time-wise between increased imports from China at decreasing prices and the loss of market share, profitability, deterioration of cash flow, etc. So in reality, the assessment of the causal link revolves around the question, did all these economic factors of the EU manufacturers deteriorate at the same time as imports from China of solar products increased at decreasing prices? An additional element in terms of the difficulty of causal link is that imports of Chinese solar products must be a cause of injury. It doesn't have to be, or they don't have to be, the sole cause of injury. It is sufficient that it's a cause of material injury, even if there are other causes of injury. This means that Chinese solar producers and all the interested parties that wish an open market here in the EU will have to rebut these allegations by saying if the EU solar producers suffered material injury, it is really caused by other factors. We can think, for example, of changes in the feed-in tariff, instability in public policy vis-à-vis solar energy that was not sufficiently taken into account by producers in their strategic decisions, such as the increase of production capacity at a moment of time that public policy was changing and was not as supportive of solar energy as it was in the past. Condition 4, and very importantly, is even if there's dumping, even if there's injury, even if it's found that the injury was caused by imports of solar products from China, no anti-dumping measures can be imposed unless these anti-dumping measures are in the union interest. Now, the union interest is not only the interest of the EU solar manufacturers, it must also take into account the interest of the unrelated importers, distributors, users, consumers, suppliers of materials and equipment. And when we look at the term users, this is a broad concept, and we would say would also include not only distributors and installers, but would also include the system integrators, the engineers, in general terms, anybody who's directly or indirectly involved with the handling of solar products and is a market player and whose interests economically depend on the growth of the solar energy market and the use of solar products. All these interested parties, as we call them, can either make known their views individually during the investigation or through their representative organization. They are all invited to make known their views, either also through a questionnaire which the Commission issues, and we'll see about that later on, or through different types of submissions, be it letters, emails, or other written data submitted to the EU. The union interest, I think, is very important in the case of this solar products investigation. Why? Well, first, because solar products are also consumer goods. And what we've seen in the recent few years is that where consumer goods were investigated in an anti-dumping proceeding, the EU institutions were attentive to the fact that the measures that might be imposed in anti-dumping duties could increase prices to the detriment of the end user and the consumer. This applies as well in this case where one has rooftop solar products that are by essence products used by end consumers. But on top of that, the growth of renewable energy is a key public policy goal that has been set by the EU itself, and solar energy definitely is a renewable energy. Now, if the Commission wants solar energy to stand on its 2 feet, as we say in Dutch, and to grow going forward, it means that the prices of the solar products must decrease with a view towards meeting as rapidly as possible grid parity, and which means that then solar energy will be fully competitive with other sources of energy. Imposing anti-dumping duties or other anti-dumping measures which has a cost increasing effect would be quite inconsistent with this public policy goal. On top of that, if you look at the value-added chain in the solar energy industry market, one will immediately see that the value added by the EU manufacturers is certainly not negligible, and it is important, but it is not the only value added, and substantial and even more value added is added by other market players, including the engineers, the system developers, the installers, the importers, the distributors, and all the market players. So if anti-dumping measures were imposed and the growth of solar energy as a separate renewable energy would be stifled, this would be against the interest of the downstream industry and would curtail the growth of the value chain in the EU. Frankly speaking, terminations of anti-dumping investigations based on the absence of union interest to date are fairly exceptional. This notwithstanding, we must bear in mind 2 things. First, since the economic crisis in 2008, the EU member states have shown a tendency to listen more and more carefully to their downstream industry and to take their voice into account before they decide on the imposition of anti-dumping measures. And secondly, and speaking from experience, what we've seen also is that to the extent that the downstream industry puts forcefully forward its interest in this investigation, even if it's impossible to avoid the imposition of anti-dumping measures, the interests are taken into account in determining what is the form of the measures, but also what is the level of the measures. So it cannot be said that these, even if there's no termination, that union interest does not play a significant role. Let me again repeat at this stage of the presentation that if you have any question whatsoever, you can type your question into the chat box. Your questions will remain anonymous and we'll be happy to respond at the end of this webinar. Let me move now to the second section of the presentation, and in particular the presentation of who are the complaining EU solar producers. Well, what we've seen in July was that an alliance called EU ProSen issued a press release indicating that it had filed an anti-dumping complaint, that it had done so on behalf of around 20 EU producers, amongst which SolarWorld and Sovello. The names of the other complainants to date remain anonymous, and more likely than not, the names will remain, or anonymity will continue to be claimed going forward. However, the composition of the complainant and also of the supporting companies of the complaint is important. Why is that? Well, that's because before the initiation of the investigation, they must meet two simultaneous conditions. First of all, the production volume of the complainant and supporting EU producers must represent a minimum of 25% of the total EU production volume of the solar products targeted. But secondly, those of the EU producers that complain or support the complaint must have a production volume that exceeds the production volume of EU producers explicitly opposing the complaint. And today it's not clear that the EU producers supporting meet these thresholds. So this may still be an important argument going forward in the next following days and weeks, because even if the Commission considers that these conditions are met and opens the initiation, we can still continue to argue that in fact the conditions were not met and that the initiation was invalid. What are the products that were targeted in the complaint? As far as we know, the products that will be covered are wafers, cells, and modules originating in China. This is a bit different, as you may know, from the US investigation that is currently ongoing, where wafers were not targeted. Why were they targeted by EU ProSen in this case? Well, that remains a bit unclear for the moment. Perhaps it is because with the inclusion of the wafers, it became more easy to meet the 25% production volume thrust, as we had understood that this was a difficult hurdle for SolarWorld to take in order to get sufficient support to clear the 25% threshold. Let me now turn to the schedule of the investigation. An investigation, if and when initiated, is limited to 15 months. So between the initiation and the final decision, there's a maximum of 15 months, which is still a fairly lengthy period. It starts with the initiation, and the initiation is a fact through the publication of the notice of initiation in the EU's official journal. That notice must be published in the EU official journal within 45 calendar days from the registration of the complaint. What we understand was that ProSen filed the complaint on the 24th of July and that the complaint was registered on the 25th of July. If that is the case, then the 45 maximum calendar days for the notice of initiation to be published expires on the 8th of September, which is Saturday. Now that may be surprising, but the official journal is still published on a Saturday, so it's conceivably possible. This being said, the latest rumors or information is that the publication might already take place either on the 6th, which is this coming Thursday, or on the 7th, which is this coming Friday. If you'd like to be informed on the publication, what you could do is in the mornings to look at the site of the EU's official journal, and you can go onto Google, type in official journal EU, you will be going immediately to the site, and if you look at the C series of the official journal, that's where you will find the notice of initiation, but rest assured also that AFASE certainly will keep you informed about the initiation. Now what is the next schedule or the next main deadline in there? Well, it depends a little bit on what will be the actual date of the publication of the notice of initiation, but it could conceivably be Monday the 24th of September if the notice of initiation is published on the 8th of September, or the preceding Friday if the publication is this Thursday or Friday. And that deadline is the deadline for all interested parties, and that covers both the Chinese producers, exporters, but also the EU producers and all the importers and users to step forward and write to the European Commission to say, my company is company X, we are distributors, we are system installers, we are engineers, we handle solar panels, our economic interests are at stake, and we would like to participate fully in the investigation. We will provide you with information, Commission, but we also would like to safeguard our procedural interests, and therefore we await or expect from you that you keep us informed along the lines of the procedural requirements. So that is a simple letter, but a deadline to safeguard all of these interests is 15 days within the notice of initiation. The second main deadline for interested parties such as importers, distributors, consumers, and other market players is the 37 days after the notice of initiation. And that will be around a little bit before or 1 to 2 weeks after the 15th of November. Oh, 15th of October, I apologize. That involves two things. First, all of these interested parties can make known their views on whether the union interests require the imposition of anti-dumping measures. Some of the importers or all the importers will receive a questionnaire. Many of the interested parties will also receive a questionnaire, and they can respond to that. Others can, if they don't receive a questionnaire, can also make known their views in any format and give evidence as to why the imposition of measures is not in their interest. This is also the deadline for all interested parties to make known their views on whether there is injury and causal link. Again, it may be a little earlier, it may be 1 to 2 weeks after. That depends a little bit on the notice of initiation and the possible transmission of questionnaires by the European Commission. Then follows a period of a few months from November to approximately March 2013, in which the Commission will be sitting behind their desks and reviewing all the information that has been filed to determine what the findings may be, what are the trends, are there union interests, is there dumping. In the meantime, also, the Commission will go for certain visits the Chinese producers, exporters, to verify the accuracy and the completeness of the data that they have found. They will do the same thing with the EU producers that will also be invited to respond to a questionnaire, and they will also visit some of the importers and some of the user industry in the EU. It will also be the timing during which all these parties can have oral hearings with the Commission. Now what are hearings? You do not picture a courtroom with lawyers in their robes and a real pleading exercise. It is simply a meeting in the conference room of the Commission, behind the desk, where one would try to set up a useful, constructive dialogue with the Commission officials and present firsthand, orally, the views on union interest and injury. We see on the slide also the date of June 2013. The EU legal provisions require that if the European Commission wishes to impose provisional measures, it has to do so within 9 months of the initiation of the investigation. If the investigation opens in September, the 9-month deadline expires in June, so it's around May, June that the Commission will have to decide whether or not at that stage it has sufficient preliminary evidence in order to proceed with the imposition of what would be at that stage primarily provisional anti-dumping duties, which are additional import duties. It doesn't have to do so. It can also decide, I don't have enough information, I don't have the support or the data needed to proceed with the imposition of provisional anti-dumping duties, or it may not be politically wise or strategically wise to impose provisional measures now. But if it does impose the provisional measures, it does so by a regulation that is published in the official journal, and then interested parties receive a 1-month period to rebut the allegations that is in the regulation in writing and to again request a hearing. The hearing will then be held in probably the 6 to 7 weeks following the imposition of the provisional measures. Again, that's simply to amplify orally, firsthand, de visu in direct contact with the Commission on the rebuttal arguments that were filed in writing. Now then, after June, July, what the Commission will do is to continue to sometime October to refine its findings on the basis of the newest information obtained and determine whether or not it should impose definitive measures. As we mentioned, the proceeding is subject to a mandatory deadline of 15 months, which expires in December 2013. Either the Commission and the EU comes up with definitive findings that are published. If it doesn't manage to come up with findings, it cannot adopt anything, then the proceeding will lapse in any event in December without imposition of measures. Who are the institutions involved in this investigation? Well, we've mentioned it already a number of times. It's first and foremost the European Commission. The European Commission receives the complaint. It reviews it to make sure that it has the sufficient preliminary information to warrant the opening of the investigation. It consults with the member states on whether the investigation should be opened, and both these procedural stages have been completed at this moment of time, but then also it proceeds with the initiation of the investigation and actually conducts the investigation. How this is done? Well, this is done by teams of case handlers. One team normally consists of 2 case handlers. They are from the European Commission's Anti-Dumping Service that is itself part of the Commission's Director General for Trade. Typically what you will have is 2 teams at least, one to deal with dumping, one to deal with injury and union interest. In exceptional cases, there may be a 3rd team to deal specifically with union interest, but that is not true in most proceedings. The Commission also adopts the provisional findings after consultation with the member states, and it can theoretically be overturned by the Council. And when we say the Council, well, this is the second EU institution that gets involved to eventually overrule Commission decision on provisional findings, as we mentioned, but it can also overrule the Commission on other decisions, such as the termination of an investigation without anti-dumping measures or the acceptance of undertakings. Just for your good understanding, an undertaking is a commitment by the Chinese producer-exporters in this case to increase prices for solar products at the level at which these prices remove the dumping that was found to exist or remove the injury that was found to exist. To date, at this very moment, the Council is also the EU institution that is the decision-making body for the adoption of definitive measures. It is the Council that decides, whereby the member states have 1 member state, 1 vote. Now there's a legislative process that is underway that will probably be finalized sometime in autumn, whereby the Commission will be the final decision-making body, subject to overruling by the Council or by the member states meeting in the Council, where a qualified majority will apply. And a qualified majority means that the largest member states will also have a larger voting weight. This legislative change, when adopted, will most likely apply also to the solar panel case, and at that stage we will have to review how the strategy works vis-à-vis the member states and how the new voting requirements will play out. There is, in any event, even with this legislative change, one institution that has a significant role, albeit a consultative role, and that's the Anti-Dumping Advisory Committee. It is a consultative body of representatives from the capitals of the EU member states. Typically, these are civil servants from the Ministries of Economic Affairs or the ministries that have economic affairs in their portfolio. The members of the committee oftentimes are civil servants who have been dealing with trade disputes since many years. They are somewhat of the technical people involved in these investigations from the EU member states angle. The committee must be consulted at each main stage, so at initiation, at provisional findings, terminations, undertakings, or definitive duties. They are consultative only, so they don't decide, but they prepare the vote at the level of the Council at the moment. And why is that? Well, before they come to the committee meeting, they have to take their instructions from their hierarchy, the ministers or their cabinets, and therefore basically the way they already express a position at the level of the committee meeting is a precursor of the way the member states will vote ultimately going forward in the proceeding, and that will remain true also after this legislative change. What are the general pattern of the voting by the member states? Well, this slide that appears on your screen now shows the general voting pattern. The green countries are the countries that typically vote against measures. The red countries are the countries that normally vote for measures. And the orange country, Austria, that's more difficult to predict where it's going to vote and how it's going to vote. Now, we often say that it's the Nordic countries that are the trade liberals and the southern countries that are the protectionist countries. I have to immediately warn you, this chart is actually a general pattern. We have looked at many different cases and came up with that chart in this way, but there are exceptions. Let me give you an example from my own country, where Belgium, that is typically opposing measures, was in favor of measures when a sole complainant in an investigation happened to be a Belgian company. And so Belgium had to support its local industry and was in support of both the initiation and of the measures had they been imposed. Conversely, if you look at Italy, we've seen fairly recently a chemical case where in Italy had both a producer interest and a downstream user interest. And ultimately, the voice of the downstream user industry was so significant and so important that Italy decided to oppose the anti-dumping measures, even if it had several producers of the product concerned on its territory. So the repartitioning of the vote, the way you see it here, is not cast in stone and will again depend on where the user industry is set up and how forcefully it makes its voice known. Let me turn to the last section of the presentation, and that is, in very practical terms, what can we do, we as importers, users, consumers, system installers, engineers, and other market players? Well, first, we've mentioned it. Please step forward and tell the Commission in writing that you wish to cooperate in the investigation and that you wish to safeguard your procedural rights so that you have a right of information, and that you can also, for instance, check the non-confidential file at the Commission so that you can be aware of what all parties have filed in this investigation. But secondly, some of you, many of you, will receive a questionnaire that will request information on your purchases, if you purchase solar products, or on your sales, if you sell solar products, or on the economic interest you have at stake. For instance, what the solar product represents in your profitability and in your profit and loss statement. When you receive this questionnaire, I can readily understand that you will be flabbergasted and think that this questionnaire is fairly complex. Rest assured again, and I believe I can speak up in name of Ms. Roussel to say that AFASE will stand ready to clarify your questions or to guide you on how to respond to this questionnaire. But if you receive this questionnaire, the best way to safeguard your procedural interest is to respond to them. Thirdly, you have at different junctures in this investigation a right to a hearing if you're safeguarded your right. It is also a good idea to make use of these hearings. You can do that separately, individually, but you can also do it in group with like-minded people. You can actually even participate in hearings that are organized by producers, exporters. Again, these hearings are fairly informal. It is nevertheless important to interact directly in a meeting room with the case handlers and explain to them firsthand how the market develops and what are the interests at stake. But fourthly also, even though if you are in the user industry, you have seen the solar energy market in the EU grow. You have seen how the EU producers developed in this market. I believe that you also have your role to play in the assessment on injury and causal link by giving your own point of view on how the market develops, why EU producers may be injured, and why this is not due to imports of Chinese solar products. That is important, and that will continue to be important throughout the 15 months of the investigation. Last but not least, the ones that will be most listening to your views as downstream user industry, or as a fact of matter also of your interest as suppliers of raw materials and equipment to solar manufacturers, are your regional and country authorities. So it is important for you to stay in touch with your member state authorities, in particular with the members of this anti-dumping advisory committee, but also with the higher up people at the ministries, like the minister or the cabinet members that are in charge of trade remedy investigations such as anti-dumping investigations, again to explain to them also firsthand what is your industry, what is your segment of industry, how you are affected by the investigation, and how you would be affected if duties were imposed. This, ladies and gentlemen, concludes my presentation, but I will now look at the chat box to see whether you raised any questions. And I'm told that there are questions. The first question is, does the concept of user also cover the end customers? I.e., does the union's scrutinization of the dumping issue take into account the macroeconomic benefits from lowered system prices for the economy and the individual? Yes, consumer interest, and even if voiced individually or through organizations, are explicitly taken into account in the EU's anti-dumping regulation. Organizations like the BUG, which is the EU consumer organization, participate in the investigations, and their views are taken into account. Now, I have to say also that it is a bit of a difficult situation, because oftentimes what the EU says is that if there are no anti-dumping measures imposed, the EU producers of the product concerned will disappear from the market. This will eliminate competition going forward and will render the consumer dependent on imported products. So it's that kind of argument that consumer organizations and consumers and we will have to rebut to say, no, this is not the case. This will not curtail competition. In fact, what you are doing is basically preventing competition from imported goods. The second question that I see being raised is, as China is not considered to be a market economy, why wasn't Taiwan proposed as reference instead of China? Now that is a very good question. The ProSun has proposed the US. However, when the investigation is initiated, there will be in the notice of initiation an invitation to interested parties to make known their view on the selection of the analog country. And I believe that it can be expected that several of the Chinese producers exporters will rebut the USA as a sound selection of analog countries and will or may propose Taiwan. So there's this window of 10 days during which all of these arguments on the selection of analog country can be made, and that will probably be fully used up by all the market participants. The third question is it possible to get hold of a copy of the presentation, please? Yes, certainly. I believe that and I'm told here by Ms. Roussel that it is already online. If you go to the website of AFASE, afase.org, you will find the presentation online. I believe that that concludes the questions raised. Then in my name, I would like to thank you very much for having listened and participated in this webinar, and I wish you a good end of the afternoon.
Thank you very much, Ms. van der Schoren, for sharing your expertise today. And thank you as well to the large group of participants who joined the webinar. AFASE remains at your disposal for support in this process and ready to respond to any questions you may have. Thanks very much for joining us, and goodbye.